So it is my hope and desire that we have a faster session so that our people can go and observe the prayers at the right time. I don't know if we should spare a moment to allow one or two more persons to join us. I see that we are currently 6 on this call, and I've not also seen our other resource person for today. I see Mr. Falarian already. He will take a session also. We're expecting Mr. Musa Abrazak to join us to take the other sessions. So while we wait for his worship, I think we can have Mr. Falarian conclude his own session, and then we'll take it from there. Once again, good morning, everyone, and you're welcome.
Thank you very much, Shay. Thank you so much for that awesome opening. And I'd like to welcome everybody once again. It's a pleasure to have you here. Just as we did yesterday, I want to do a quick sound check to be sure that my sound is clear. Sure that my sound is clear.
Yes, the sound is clear today.
Awesome. Thank you very much. Now, thank you so much, Jahid. As Shay had said, actually today, Mr. Amulu called me yesterday, and told me that he received a hearing notice to take a judgment today, this morning, and that he feared that he'll be in court during the time that our session will be holding. I'm supposed to attend today primarily, and then maybe just do a session, but I promised that I will stand in for him in the event that he's unable to make it. But I have the assurances of his worship, Mr. Musa Ene, that he will be here with us. I understand he's planning to, he's joining. So welcome everyone. I think we should just get straight to it since we're already here. Today's session will be very practical, and I'll just do a very quick overview of what we covered yesterday. Do a very quick overview, and then we'll go into today's session proper. And like I said, today's session is actually going to be very practical, because one of the things we'll be looking at today will be the attitudes of the various institutions. So we're going to analyze and highlight some of the major law enforcement institutions that we have in Nigeria, and some of their attitudes towards arrest, some of the major complaints that people have against them also with regards to the abuse of arrest powers. And this is very important. One of the things that you are taught in law school, one of the first things we are taught is to know your court. And I think it is equally important to know the agency that you're working with. That helps you. That can make the difference, the distinction between liberty and otherwise of your client. So for purposes of a quick recap of yesterday's session, we looked at arrest generally, started with an introduction to arrest, and we defined arrest as the act of taking a person into custody. Look a little more closely into that today, the act of taking a person into custody. And we also saw that constitutionally, it is the duty of the police and of law enforcement agencies to investigate matters. So they have a constitutional and fundamental duty to investigate. However, that duty to investigate is not a duty to arrest. And you find that a lot of the time, I find, quite unfortunately, when lawyers file fundamental rights enforcement claims against law enforcement agencies, and these claims are struck down or you find in some of these claims that there will be language that suggests that perhaps the objective of the reliefs is to stop the police from investigating. No, the objective, should the police have a fundamental and acknowledged duty to investigate offenses. That is manifestly clear and is not in dispute. What is in dispute is when the investigative powers of the police or other law enforcement agencies is abused, or at what point does the exercise of that power stop as investigation and cross over to abuse? That is the question that the court should be asking. It is also the question that lawyers must ask. It's the same question that all lawyers must ask when framing fundamental rights enforcement discussions or conversations. So we looked at that general introduction, and we talked about arrest as a tool of law enforcement, and as a tool that, as a limited tool. I didn't mention, but I have had the opportunity conducting trainings for law enforcement agencies in several states across the country. I've also had the privilege of acting as lead consultant on the review of the criminal code laws of several states across the country as well, as a consultant for Partners West Africa. I've also had the opportunity of working with several states also to review their plea bargain, in fact, to draft plea bargain guidelines and sentencing guidelines for courts. And the one through line that you find in all these interactions is often that it is obvious that there is a widespread misunderstanding among lawyers, unfortunately, and also among the public, about, and among law enforcement, most importantly, around the limits of the powers and how to exercise their powers constitutionally. So we then looked at, after looking at the scope of, just briefly at scope of arrest powers, we looked at the constitution, the colonial background, our colonial history, and how that colonial history has affected the way and manner in which arrest attitudes are, are framed or were framed with law enforcement. Then we have looked at that. We have also looked at the historical precedent, because again, the laws that we institutions, particularly the Nigerian police, which was formed, which came from the warrant officers, and I think was formed in 1943, 1st of April 1943, the Nigerian police force, adopted many of they operated under the ideology of the colonial authorities at the time. And we saw that the purpose of arrest at that time was not really meant for citizens of any country. It was meant to serve colonial objectives. Then we looked at some of the English common law influences and how some concepts in English common law have now come to frame our laws today. The English common law developed over several centuries, and it is actually the bedrock of the law that we practice today. We have not had the opportunity yet of developing a truly local and indigenous set of laws. I think this is one of the reasons why criminal law is you're welcome, Idris. This is one of the reasons why criminal law is residual for the states, because it is the function of the states to enact laws that are consistent with the morals and ideologies of their various localities. And I'll give an example. In Taraba, for example, we were doing a review, when doing a review of the criminal code law, and we discovered in conversation that because of the nature of the terrain, Taraba is a very mountainous and hilly state. We discovered that most of the water supply, for example, is supplied by a water board. So, and as a function of that, public utilities like water are metered. In a place like Abuja, a territory like Abuja, Abuja has a lot of people use boreholes. Many people use the water board, which provides metered supply. But the vast majority of residents in the FCT do not use water board, not use metered supply, of for their water. But in Taraba, about 90-something%, in fact, probably 99.9% of residents use metered supply of water. And so the question of theft of water or of metered items became an issue. And if you look at the traditional definition of theft, something capable of being moved, the question was, how do you steal water? If we were to go to a pond and fetch a cup of water from a pond, have you stolen water from that pond? Do you understand? And so that became an issue that had to be addressed, and it's an issue that is unique to the people of that state. And it's an issue that should speak to their own internal morals and ideologies. In the same state, they rejected the idea of bigamy. They said, look, bigamy is unknown to us traditionally, and so on and so forth. In some other states, for example, in one state, another example is with theft, for example. In some states, the attitude to theft may be in some cultures rather, the attitude to theft may be to put an emphasis on the owner of the item, to protect their item. In some other places, the emphasis may be on the person who steals, to restrain that person from stealing. So at the end of the day, states should be allowed to define what conduct is acceptable and what conduct is not acceptable by virtue of their own internal laws. And that is why criminal law is residual. And so we looked at the common law influences in our criminal law. Then we looked at the law today and where it stands. We talked about the transition from the punitive system of government to a more rights-based or human rights-based frame of law enforcement. And that is what we apply today. In fact, the Administration of Criminal Justice Act and the laws actually interpret they adopt a human rights-based approach, and the ACJA infuses and domesticates principles of the Constitution, principles from the Constitution into the provisions of the ACJA and ACJL, such that in a very practical way, we'll look at some of them in some more detail today. And then we close by opening the conversation on Section 35 of the Constitution, which deals with the right to personal liberty. We looked at some conditions under which that right, that fundamental right, can be derogated from. And we talked extensively about reasonable suspicion. Then we looked at how this reasonable suspicion is often obviated or breached by law enforcement agents when civil matters are brought, are presented as or framed as criminal matters. And so today, I'll be sharing my screen now. Today, we'll be looking at, we're going to the second session, his worship. I think maybe what I'll do is I'll start and then I'll hand over to his worship to take over from me, and then I'll end. But this session is very practical, and we'll see that it is actually extremely practical, because I want our conversation to target in specific detail how law enforcement, how to respond proactively to law enforcement agencies so that we can deal with issues that our clients face, efficiently and effectively. So just to confirm, can we see my screen? My screen visible?
Yes.
Just okay, awesome. Awesome. So we can proceed then. Okay. So now I think we'll start the conversation from where we stopped yesterday, and we look at section 35. We talked about where the rights start from. Now, section 35, going forward from there, section 35 sub 2 talks about the rights of an arrested person. We'll look at how this comes down to, how this boils down to the ACJA in specific detail. But with regards to the rights of the arrested person, immediately a person is arrested, the suspect must be informed of A, the reason for the arrest; 2, the right to remain silent; 3, the right to consult a legal practitioner. In fact, I should take it logically in sequence. It would be the right to a legal practitioner if they cannot afford one, and then the right to consult a legal practitioner of their choice. Now, these we call them the Miranda rights. In practice, you find that most suspects are actually not properly informed. And unfortunately, I think the reason is because law enforcement agents try to use shortcuts to achieve their objectives. If you understand how they operate, we will understand why this is so. Due to lack of funds or lack of adequate funding, you find that most of the majority of what we call investigation in terms of law enforcement practice is actually limited to statement taking. It's limited to statement taking. Please give me. And so, because law enforcement investigations are limited to statement taking, what you find is that the law enforcement agency is desperate to take statements, and they must take their statements at all costs. Sorry about that. His worship is trying to join, and he called me to ask to make some inquiries. But I think, Shay, is it okay if I send him a number?
Very well.
Okay, I'll send you a number as well. So thank you. So I was saying that many times we think that some of these rights are, that the Miranda rights are actually theoretical, but they're not theoretical. It's not theory. They serve a purpose, and the purpose is to ensure that the statements taken from suspects are not coerced. They are made voluntarily. And in fact, if law enforcement agents understand, if they're able to understand that, that they can achieve their objective without much incident, it makes the process of interviewing or interrogating, or whatever you want to call it, interviewing the suspects easier. And so because you have a situation where most of them are limited by, they are limited by the need to obtain statements. We'll look at what that is shortly, and why that, and some of the implications of that. But because they are restricted only to, they are forced to investigate by way of statement taking, there's pressure on them to take statements. And that leads to many challenges, a lot of the friction. And if lawyers understand, once lawyers understand that, look, all they want, their investigation is statement taking. But there are ways that we can even help them with their investigation that would enrich the case, especially when you have a situation where the client is innocent, the client is actually not guilty, or the matter is actually civil in nature. It makes your intervention much more reasoned and convincing. It makes our interventions much more reasoned and convincing. Now, I was saying that the interesting part is that with regards to, so the question I always ask is, what is the implication of failing to comply with these provisions? Because the ACJA and the various ACJL actually explicitly require that these provisions should be complied with, that a person who is arrested should be informed of these rights, the existence of these rights. So the question then is, what is the implication of the failure, the event that law enforcement agents fails to inform the suspect? What is the implication? For some of them, the implications are, it may just end up as bad practice. But you find that in the long run, for things like the right to consult a legal practitioner, it may end up vitiating, especially in the light of recent Supreme Court decisions, it may vitiate the so-called statements that they are in such a hurry to take. And which is why you find that many police officers or law enforcement agents will tell you they want to question suspects quickly before the suspects have the opportunity to speak to a lawyer. And the reason is because they believe that they can obtain a confessional statement. But a confessional statement on its own it must still meet some legal thresholds, basic legal thresholds. It must be direct. It must show a connection between the offense committed or the offense alleged and the person who is actually confessing. So that in such a way that it connects the elements of the offense with that person. And once that is so it is not just enough for someone to say, yes, I did it. Because a person can be procured through torture to admit to doing something that they did not actually do. So when a person confesses, it is important that the person must confess and must also provide information as to how the offense was committed, particulars, why the offense was committed, and so on and so forth. So the objective of law enforcement should not just be to obtain a confessional statement just for the sake as part of the investigation. No, they should anchor their investigation on other forms of evidence. We'll come to that briefly. So, suspect has rights. The second thing to note with regards to Section 35 is the 24 and 48-hour rule. And this is a rule that is often flouted by law enforcement agents. And it is flouted because most times, in most cases, and again, let's remember that when we say law enforcement agents, we're talking about, I might say police, I might say law enforcement agents, but we're talking about all agencies that have the power to arrest and to detain. All agencies that have the power to arrest and to detain. The Administration of Criminal Justice Act applies to every single agency that has the power to arrest and to detain. Welcome, everyone. I'll share I think midway or halfway into today's session, we will share the link for CLE to register for your CLE points. So I was saying that the second thing to note with Section 35 is the 24-48-hour rule. And in fact, for me, what this rule does, if there's a court within 40-kilometer radius, then a person who is arrested, we talked about arrest, and we said the purpose of arrest is to present a person, take a person to court. An arrest should not be effected for the purpose of investigating an offense. The actual purpose of an arrest is to present the person arrested before a court of competent jurisdiction for their trial. We'll look at remand orders, and I suspect that His Worship may also speak to circumstances under which the court grants remand orders and how lawyers, well, we actually have it in my own second session today. We'll discuss how lawyers can deal with remand orders, because the remand procedure was introduced into the ACJA and ACJL as a means to stop or to avoid what we call the holding charges, the abuse of this right to personal liberty by the use of holding charges in the past. So what it means, and this 24-48-hour rule applies to all law enforcement agencies. Any person who is arrested and detained by a law enforcement agent must be released either conditionally or unconditionally, or charged to court within 24 hours if there's a court within a 40-kilometer radius, or within 48 hours if there's no court within a 40-kilometer radius. This means that whatever, regardless of the bail conditions, whatever the bail conditions are, no matter how stringent or unstringent they are, if that person is not released within 48 hours or 24 hours, then that person's rights has already been infringed upon. The person automatically becomes a victim. The person becomes a victim of human rights. His worship. The person becomes a victim of human rights infringement. I'll try and move very quickly. Now, it's important for lawyers to understand how Section 35 works and the way the ACJA and the ACJL interprets the rights or reenacts the provisions of Section 35 to protect suspects, to protect defendants, to protect Nigerians, really. And Section 35 allows us to challenge unlawful detention, to demand prompt bail consideration, because if a person, in fact, administrative bail, in my opinion, you know, I said yesterday that arrest is is a very blunt tool. It's actually, law enforcement has a wide range of tools, you know, including the use of force and several other soft tools. But arrest is one of the tools, but it's a very blunt tool for law enforcement. Why? Because immediately a person is arrested, there is a constitutional clock that starts ticking. So a person may be arrested and detained, and then you give the person some conditions, easy conditions, or even difficult conditions for bail. If by the end of the 48-hour where there's no court within a 40-kilometer radius, that person cannot meet those bail conditions, then the law enforcement agency must release the person. Otherwise, they stand the risk of violating that person's fundamental rights. Of course, we talked about remand orders. In the event that they discover that, oh, we are unable to charge this person, then there's the option of remand orders. But even when applying for a remand order, the law enforcement agency is still required to demonstrate that there's a prima facie case that has been established against this person. And we'll talk about, how to use those. So now we'll look at what legally constitutes an arrest. And this is important because there are so many other things that within the, like I said, within the criminal justice system, law enforcement agents have a lot of tools. And many of these tools, there are many tools, but not all of them is an arrest. So it's important to understand the distinction and difference between an invitation, an interview, questioning, and an arrest. And this distinction is very important because sometimes a client can be invited, and I think the Nigerian police force is very professional in this regard. They sometimes even send letters. You are hereby invited to interview with XYZ. So suspects are told, oh, we are inviting you. There's an agency that will even write and say, please, we would like you to interview this person in connection with XYZ. The person will not be told that they are going to be placed under arrest. But the practice of arresting people who come in voluntarily, which effectively is an arrest without a warrant, which we look at, underscores some of the abuses of the arrest powers of many agencies. So a person may be told, oh yeah, this is just an invitation. We just want to answer a few questions, or please come in for a discussion. Now, regardless of what all these euphemisms, whatever euphemism may be used, there's a distinction between the real incident and the legal incident of whatever transpires. And this is important because a person may be placed under arrest without the word arrest being used. In fact, in practice, what tends to happen is that many agencies would say, or some of these agencies, particularly, I think police and EFCC, the person will be told this statement is being made under caution. The caution actually are the words of caution that we discussed. You have the right to remain silent, but they rarely say those actual words of caution. And I had a conversation during the training session with some mixed law enforcement agencies. I asked them to repeat the words of caution, and they said, oh, the suspect has the right to remain silent, etc. And then I asked the follow-up question, okay, so what happens when the suspect says, oh, I choose to exercise my right to remain silent? And everybody erupted, and all the participants erupted saying, then you detain the person, you do this. And I said, do you see the discrepancy there? The law tells you as a law enforcement officer that somebody has the right to remain silent. But if the person exercises that right that you just told them they're entitled to, you get upset. So that should tell you that there's a problem with your internal, there's what you call there's cognitive dissonance at play. And there's a problem with their own internal process. So the person either has the right to remain silent or the person does not have the right to remain silent. And quite interestingly, yesterday we talked about how law enforcement actually need more training, and I 100% agree with that. So for the purpose of just framing it through the point of view of the act, an arrest occurs when a person's freedom of movement and personal freedom of movement is intentionally restrained by lawful authority. And the restraint can occur through physical force, verbal command, or a display of authority that indicates that the person cannot leave. And we discussed yesterday the conditions under which the ACJA requires the use of restraints, handcuffs. And we discussed that the way the act is worded, the use of restraints is not necessary if the suspect submits to the authority by word or conduct. The suspect submits to the authority of the detaining officer. Okay, so arrest, as we said, does not require formal words. Simply, you don't have to hear, or you are hereby under arrest. What tends to happen in practice, because we want this session to be very practical, what tends to happen in practice is that the person is told this statement, the person is making a statement, the person is told this statement is made under caution. Or what may happen is that an invitation extends into an arrest, or becomes an arrest effectively. So an arrest occurs when a person is detained against their will, or leaving is no longer permitted. And this distinction is important because it helps us determine when constitutional rights are triggered, or when detention begins to run. Now, I would say that I think the police also, well, most law enforcement agencies confuse this idea of the extent or the limits of the power of arrest. And many of them think that when a person is invited, that by simply inviting someone to attend, that invitation is the same thing as a summons. And it does take an invitation. It's not all invitations that must be accepted. In fact, sometimes for the traditionalists, or for those who are still traditional on this call, when you invite someone to come and eat, it's not all invitations to come and eat that we expect that. Sometimes it's we just say come and eat out of politeness. So technically speaking, not all invitations must be accepted. In fact, an invitation can be declined. So you can say, thank you for inviting me, but I don't want to eat, or I would rather not come, or I don't want to come. Now, the problem is that our law enforcement agents tend to think that they have the power to summon. Interestingly, in our jurisdiction in Nigeria, it is only the courts that have the power to issue summonses to any person to attend or to do anything. And it is only the courts that can issue warrants of arrest still. So anyway, that's a trajectory that I don't want us to stay too long on. But so understanding that helps to frame or appreciate what the mindset of the average law enforcement officer is. Which is why, so sometimes there was once upon a time there was this incident that happened. Some officers went to a site to invite site manager, the client, and they called me, and the site manager said, I will not come until my lawyer is available. And the officers got upset, and the situation became very tense because there were workers on site, and the workers were saying, take the site manager who will pay us. So the situation got very tense, and there were only two officers there. So they put a call through to me. And I spoke with the officer, and of course I understood. I said, yeah, are you inviting him? He said, yes. So I said, this is an invitation. Don't worry, he will come. The officer said, no, he must come with me now. I said, okay, so what you're saying is that he's under arrest. The officer said, no, we're inviting him. I said, okay, in that case, I promise you he will come. And the officer said, no, he must come with me now. So I said, in other words, he's under arrest. And the officer said, yes, he's under arrest. So immediately I told the person, I said, well, you're under arrest. So please go along with the officer to the station. Now, don't wait for anyone. Somebody will join you at the station. Why? Because immediately, once it is an arrest and not an invitation anymore, then the proper thing to do is to comply with the police officer, with the officer. And so that was done. I told the officer, look, you don't have, since you said it's an arrest, but as you said it's an arrest now, then this and this and this must happen. So we got to the station and then we got to the end. We were able to get to the end of the matter. Now, unfortunately, in Nigeria, many arrests actually begin as invitations. These invitations may be either written invitations or telephone calls or requests. Now, an invitation on its own is not an arrest. And the fact that one is invited does not necessarily mean that that person will be placed under arrest. Because again, some clients become very wary, very skeptical, very scared. And they are concerned that, oh, I may be detained. And in truth, we all agree that law enforcement agents abuse their powers or their powers of arrest. This may happen, but it is not all invitations that will automatically lead to arrest. But an invitation may lead to an arrest, and when that happens, the lawyer has to be aware so that it can form part of the things that you advise your client with. Now, in Nigeria, there are only two ways that an arrest can occur. An arrest may be with warrant or without warrant. The default rule, in my very honest and humble opinion, is that all arrests shall be by warrant. And I'll explain why this is the default rule. All arrests shall be by warrant. And what is a warrant? Let's drill in a little. A warrant is a command issued by court directing somebody or some persons to do something. You can have there are different types of warrants. You can have search warrants, arrest warrants. There are different types of warrants. A warrant, but importantly, a warrant is an order issued or a command issued by a court. The colonial practice of warrant cards, where the police would use they will say their ID card is a warrant card, has long been abolished. It doesn't apply anymore because the police cannot issue warrants. You cannot be the judge, the jury, and the executioner. So the police cannot legally or lawfully issue warrants. Only the courts can issue warrants. So arrest in Nigeria may occur in two ways: arrest with warrant. And for an arrest with a warrant or arrest by warrant to take place, the arresting agency must approach a court to obtain a warrant. And before they can approach a court or convince a court that a warrant should be issued, some facts must be placed under oath before the court to demonstrate the reasons why that arrest is necessary. And this is because the primary purpose of arrest is to produce a person before a court, and not so that an investigation can occur. That is an exceptional use. And so we find that warrants may be used when a defendant fails to appear in court, or a suspect does not appear in court, or where there is sufficient evidence to justify the compulsory attendance of any person in court. And so in those situations, the court issues a warrant for the arrest of that person. Now, arrests without warrants are provided for under the ACJA. And arrests without warrants are restricted to a limited category of situations. So the law enforcement do not have an open template or an open check as to the circumstances under which persons can be arrested without warrants. In fact, this is one of the areas where vast majority of abuses occur in Nigeria, because most arrests in Nigeria occur without a warrant. And if we look at the provisions of because we're not all from one branch, but if you look at all the provisions, if you look at the provisions of the various ACJAs and ACJLs, you will find that there's a limit, or there are limited or enumerated circumstances under which an arrest can be effected without a warrant. In fact, if you look at section, I think it's 34 of the ACJA, section 34 gives chief magistrates the power to visit detention centers every month. And then section, I think 33 deals with reports of persons arrested without warrant by law enforcement agencies. So in situations where a law enforcement agency arrests a person without a warrant, they must give a report to the court. And this is because arrests without warrants are the exception to the rule and not the rule itself. The powers are actually limited by the Constitution. Now, okay, let me just try and speed through this. So now we want to look at some common unlawful practices, unlawful arrest practices in Nigeria. Let me just quickly take a step back to recognize His Worship, the Right Honorable Musa Abdulrazak Ene. You're welcome, sir. He joined us in the middle of my presentation. Once we'll do a proper introduction.
Thank you.
Welcome, sir.
Thank you.
Yes, sir. He's
God
our
bless you.
organ. Yes, sir. Mr. Shea had done, but I'll soon round up. Once I round up, we'll pass the Shea will do a proper introduction for you, my lord, sir.
Okay, then.
Thank you, sir. You're welcome, sir. So now we have, excuse me, we have, I've highlighted some unlawful practices, arrest practices in Nigeria. And it's important to note that the ACJA was designed to eliminate some of these unlawful arrest practices. And this is because for purposes of litigation, in fact, in many cases, the criminal matter is actually killed. In fact, the case in court dies at the stage, in many cases, at the stage of arrest. In some cases, because the people that, where law enforcement do not properly profile people who come before them, somebody makes a complaint against another person. That person is still a respondent until investigation has occurred before that person can be deemed to be a suspect. The person is a suspect when a reasonable suspicion that they have committed an offense exists. And the only way you can determine whether there's such a reasonable suspicion is when an investigation has occurred and that investigation has revealed the existence of a prima facie case, or the existence of the preponderance of the ingredients of that offense. And so because we find that law enforcement, especially investigators, do not have the ingredients of most offenses at the back of their minds when investigating, they end up, that situation alone can destroy the entire case. So a person who, in homicide cases, for example, since we're being practical, I know that homicide cases are investigated at the state command level and not at the station level. So once there's a homicide, that is reported either at the divisional level or at any of the other police posts or whatever, the whole case file is transferred or transmitted to the state command. Now, what tends to happen is that the law enforcement officers will arrest everybody. So there was this very interesting case some years ago. Somebody was killed. She had a lady who rented an apartment in a very popular estate in Abuja in the FCT was killed. The lady worked with the presidency. And so there were interests, quote unquote. And what happened was that the matter was taken to the state command and everybody, she had just moved into the apartment. Her agent was arrested. The agent of the landlord was arrested. The lawyer, her own lawyer was arrested. The lawyer to the landlord was arrested. Everyone connected to that transaction was arrested, and they were all to be detained. It took some intervention to ensure that just the lawyers were released. And at the end of the day, you find that these are people who probably might have made good witnesses, but still, rising from the fact that they have first been arrested and detained, and some of them were detained for about 3-4 weeks. Do you think these people will be happy to come and give evidence in court as witnesses? More likely, the answer will be in the negative. So you find that law enforcement already creates a problem for the case in the long run, because somebody who should have not been arrested was arrested. A person who is supposed to serve as a witness was arrested and treated like a suspect. So we find that in many cases, premature arrest or unlawful arrest actually harms the objective of law enforcement and rather than help. So ACJA outlines some. We looked at them yesterday. I'll try not to dwell too much on them today. But Section 8 deals with arrest for civil or commercial disputes. And typical examples, we looked at them yesterday: debts, contractual disagreements, even husband and wife conflicts nowadays, find their way to law enforcement, particularly the police, because the police is closest to most citizens. And what you tend to hear, we talked about it yesterday, the police will say, when a lawyer says this matter is civil now, police say there's an element of criminality, and they may want to charge the person for criminal breach of trust. Interestingly, I was telling someone that the offense of criminal breach of trust doesn't mean that, oh, I trusted you, you trusted me, then I breached that trust. The criminal breach of trust is an offense that actually comes from the Victorian era. And that is because the trust system, because people didn't live long before penicillin and some of these modern advances in medicine, were discovered. People wouldn't live long. So it was common for parents to appoint other persons as trustees for their children. So you appoint somebody as a trustee and say, okay, I'm going to transfer these lawyers, we did equity and trust. I'll transfer my property to you to hold in trust for my children in case I die before my children become of age. And the trustee, because the legal title that is often transferred to the trustee, these trustees have a stand in a fiduciary role to the beneficiary. The beneficiary may not be able to exercise, full control of the property. And so what the law did was to create an offense for a trustee who breached the fiduciary trust rule. And so criminal breach of trust requires that there must first be a trust relationship. But what do you find before most of our courts? You find transactions being brought to court as criminal breach of trust. There's no trust relationship that exists. And the trust there is a legal trust. So this is what happens. And unfortunately, lawyers, are at the root or responsible. We talked about it yesterday, that lawyers should also not draft petitions, because when we do that, what we're doing, we complain that our profession is being eroded, but yet we then use our own hands to create the circumstances that actually erode the profession that we're complaining of or that we're trying to save. So the ACJA makes it clear that criminal arrest should not be used as a tool for civil enforcement. And one of the major reasons is that it actually has a way of reducing the trust that the public has in the justice system. When you abuse the criminal process or criminal procedure, it erodes trust in the justice system. But this abuse occurs frequently because people perceive civil litigation as being slow. It actually is not slow, but that's a different conversation. Then many complainants believe that police pressure will help force settlement. And the trick is that what tends to happen is that nowadays people will file fundamental rights enforcement lawsuits. So imagine that somebody is owing your client some money, the police is brought in, and then that person files a suit, sues your client and sues the police, and then it creates a web that becomes very difficult to untangle. Section 7 of the ACJA deals with arrest in lieu, arrest by proxy. And this is an area where there is a lot of abuse. Although I think the incidence is much lower now, but there's still significant abuse. And this is when police arrests, or when law enforcement arrests somebody, not because that person committed an offense, but for the purpose of compelling another person to appear. And you find this happens, maybe the target may be a suspect's spouse, a parent, a partner, another director in the company, or a colleague or employee. And in fact, with EFCC do this a lot. They will invite a director in a company and arrest that director, or tell the person to produce somebody else. Arrest by proxy is illegal. It's illegal. ACJA prohibits it. We've talked about this. Arrest by proxy, what it does, under our criminal jurisprudence, every person is required to stand to be held responsible for their actions. It is wrong. Sometimes the process itself is even worse than the outcome. And the process, a lot of the times, is the punishment. So anyone who goes through this process oftentimes will leave feeling very bitter. And these are the things that lower or reduce, from a risk assessment point of view, these are the things that reduce the trust of the public in our justice system. And we're the ones who stand to lose at the end of the day. The third common abuse is prolonged investigative detention. And this could occur in many ways. It could occur in situations where, and this is because detention has to be limited, because the Constitution requires that suspects must be brought to court within a reasonable time. And a reasonable time is defined as 24/48 hours. So arresting someone for the purpose of detention, for the purpose of investigation, is wrong. Ordinarily, and the ACJA provides and ACJLs provide for the obtaining of remand orders, but every remand orders have time limits. And in many cases, the prosecution is often required to justify why the remand order should be renewed. In the FCT, it is first 14 days, and then it can be renewed for two subsequent occasions, but there must be prima facie evidence as to why the detention order or the remand order should be renewed. A corollary of the prolonged investigative detention is the constructive detention, which is that there's a case that is a matter that I learned about. We came into the matter discovered what was the situation. This person, there was a transaction somewhere. This person was invited by, I mean, we are lawyers, so we can, let me see. And so this person was invited, and the person was put on administrative bail, and the person had to keep coming, and the person was going there for 3 years. Every Monday, his passport was taken under the guise of, investigation. That is a flagrant, it's an outright breach of that person's warrant. And so a person may be detained, but may not be in the cell. That is constructive detention by effect. And all these things whittle away the public trust and confidence in the criminal justice system. So from a risk management point of view, it is problematic. But in spite of all of this, I think it emphasizes the need for professional engagement with law enforcement agents. Yesterday, we talked about the dichotomy between the role of our roles as barristers and solicitors. We said that the temperament of a barrister is different from solicitor's temperament. But in Nigeria, we are called to serve as both barristers and solicitors. Now, in conclusion, I want to just quickly highlight some patterns of arrest abuse among law enforcement agencies, common patterns. And we'll start with the, let's do this. We'll start with the start by looking at now it's important. One of the first things you learn in law school is when you're appearing before your court. Our arrest laws generally tend to be uniform. The provisions of the Constitution are uniform, but different law enforcement agencies have developed different organizational attitudes and practices and patterns. And if you know how these patterns work, it helps us as lawyers helps us advise clients properly, and helps us respond strategically. For example, there's this agency that is fond of arresting people, detaining them, then obtaining remand orders while giving the parties unreasonable bail conditions to meet. So this particular client was arrested, and we suspected that an application had been filed. So I sent my junior to court, to the registry. We did our search, and we discovered that indeed, an application had been filed. In fact, a charge had been filed, and the charge was coming up. The person was arrested on a Friday, and they were telling him, don't worry, go and bring level 14, level this, level that for bail. And it turned out that we found out that a charge had been filed, and the hearing date was on Monday. So before going to see the client, we just told him, see, these people are not likely to release you. You'll be here till Monday, and you'll be charged on Monday. So it made it easy for everyone and we're not even given a hearing notice. So on Monday, the agency was surprised to see us in court, at the arraignment. We were in court, the person was arraigned, and immediately we applied for his bail. We had filed the bail application, so on. So if you know the agency you're dealing with and some of their unique patterns, practices, even both the good, the bad, and the ugly, it makes it easier for us to engage, to represent our clients better. Now, the Nigerian Police Force is the number one law enforcement body in Nigeria. And they are the closest to the people. And so by volume, we find many people who have questions or issues with the breach of their fundamental rights. By volume, probably point to the police. But I think the police are actually, to a large extent, they have the most developed system of internal system. They have one of the most developed system of internal checks and balances. though a lot of people don't know how their internal complaint procedures work. But some of the common complaints that you hear against the police include arrests arising from civil matters, debt recovery, arrest by proxy, use of detention as an investigative tool rather than conducting investigation before arrest, prolonged detention without prompt arraignment, and pressures to settle. In fact, what you even find in police is that because many lawyers are not senior police officers, when lawyers give their opinions that, oh, this matter is a civil matter, they are often overruled by their superiors. Okay, EFCC. The EFCC was set up as an investigative body, you know, and in response to Nigeria's obligations to counter anti-money laundering and terrorist financing. But EFCC has now become more than an investigative body. Now they prosecute, they investigate and prosecute offenses. And some common complaints raised against EFCC include extended investigative detention. That is very common. Frequent reliance on confessional. All law enforcement agencies, almost all of them, rely on confessional statements during investigation, and that creates a problem, but we've talked about that already. Broad interpretation of economic crimes leading to arrests in complex commercial disputes. You could find a situation where I once saw a news item. I think somebody was arrested for for organ harvesting, was charged and prosecuted by EFCC. And I said, organ harvesting, what does the EFCC have to do? And they said, oh, the person sold the organ, so that's a financial crime. You know, the problem there is that if the officers, or if the investigation was not properly handled by experts, they will actually undermine the main charge or the primary crime that was committed there. Then repeated invitations that eventually result in detention. So, in fact, EFCC staff tend to get upset if they invite someone, a client, and the person does not honor the invitation. They get upset, and most times they think that their invitations their invitations are warrants. Okay, NSCDC. I think one of the biggest challenges or complaints I heard recently about NSCDC is they say civil defense. So people say, for one of them, there was a matter that I had to intervene in recently, and this civil defense officer, was it purely debt recovery. So this person, they actually signed an agreement in the civil defense office, and because they now have a fraud unit, anti-fraud unit. They signed, and the respondent was requested to pay 50,000 naira for file. And, you know, just some funny things. The person was told to pay the money into the head of that unit's account. And these terms were written into the agreement that was snapped. And I said, how does this work? You know, and when the person defaulted, quote unquote, because there was an issue with the transaction, they started threatening to arrest the person. And they said, oh, we are civil defense, we can do civil matters. And we took the intervention of some of their superior officers to tell them, look, you've gone beyond the scope of your lawful duty. Okay, DSS or SSS, depending on how you choose to look at them, whichever law you're looking at. I think the primary complaints against DSS is right of access to suspects by lawyers and their family members. And there are also concerns that DSS tends to detain people because of the nature of their mandate without filing charges. So you have detentions that extend beyond the constitutional time frame. And I mean, I guess the jury is out, but the important thing is to understand at what point the breach has occurred, so that if one needs to challenge that breach in court, you can actually challenge it effectively in court. So I think that brings us to the end of my So that brings us to the end of my session. So Shay, I guess if there are any questions, maybe we'll take his worship and then.
Yes, thank you, sir. Thank you. I will propose to take his worship first, so that we can take all the questions together afterwards. Yes, good afternoon, everyone. We are very glad to have you attending this session so far. The hearing for the past 1 hour is that of Mr. Folari Aluko, the former chair of the Abuja branch of the NBA and the chair of the CLE committee or the Directory branch of the bank. We've had a wonderful session so far, and I'm about to introduce his worship, Honorable Musa Abrazak Eneye. He is the chairman of the Noise Association of Nigeria chapter. He currently heads the Kuje and the Cedar district of the FCT. His worship has had the rare privilege of being tutored by Prince Bola Jibola SAN KB for about 5 years. If you know Prince Bola Jibola, he was a judge of the International Court of Justice, Hague, Netherlands. His worship, Honorable Musa Abrazak, is a very senior university with vast experience in the education of criminal trials, evidential analysis. He has done research and written legal opinion, legal documents on maritime law, aviation law, oil and gas, to mention a few. He brings us this afternoon the vast experience of the bench to the conversation we're having on arrest and bail protocol. So for lawyers in the house who work around police, who work around the Nigerian Army, around immigration, or any other law enforcement agency who have the powers to arrest, like Mr. Folari has established, to investigate, to detain, and all of that. This session is something you can't afford to miss. So when the magistrate talks to you about bail, about arrest, you should pay attention and take notes. So with the privilege I have, I want to welcome His Worship, Honorable Musa Abrazak, to take us in the next segment of this session. You're welcome, sir.
Thank you. Thank you, colleagues. Thank you, gentlemen. I am privileged to be here today. And I'm sorry, I may not be able to speak for as much as I would love to, because it's already, today is a half day and it's almost time for prayers. I will soon be off to the mosque. But I have heard a whole lot about what Mr. Aluko said, who is always very, very, very clinical in his speech and delivery of his mastery of the law. All he has said are actually what it is as per arrest, bail, and of course, preventive justice when we talk about preventing crime. Now, the ACJA was developed to improve upon the previous positions of the Criminal Procedure Code, which was in existence at that time. And the Criminal Procedure Code had a lot of lapses, with we magistrates struggling to amend or contain in the course of it. Things like plea bargaining and the rest of them were not there, but they are now introduced here in the ACJA. And when we talk about arrest simpliciter, if you look at the ordinary lay meaning of it, is to seize someone by legal authority and take them within custody, lawful custody. You cannot just seize anybody like the way some people will do and say this person committed crime and they lock him up in their store for a day or two that will now become seizing the person without legal authority and thereby putting him into unlawful custody, which may now be interpreted as kidnap or some other criminal activity that is far away from arrest. Now, who may arrest? This has been spelled out in our laws. You can see it from the ACJA, and then, of course, it is stated there that if you suspect, reasonable suspicion rather, or apprehension of violence, or an attempt to escape lawful custody after committing an offense can warrant the arrest of someone, even without a warrant. And the police may also do so, and all that. But the issue is there must always be that lawful nature when arrest is to be done, when restraint of a fleeing suspect or of someone who has just committed a crime or who is about to commit a crime is to be done. Now, you have seen a whole lot of persons nowadays. It's not just the police that arrest anymore. The DSS, the ICPC, the EFCC, the Civil Defense Corps, and a whole lot of them bring suspects to court. And they don't just arrest, they even want to prosecute the suspects so arrested. And once this is done, if you ask them, they will cite their laws that allows them and gives them the power of both arrest and prosecution in court. So it's now a very interesting time that we're in, because previously powers of arrest were limited to the police and some few other agencies, the DSS and maybe FCC and the rest. But now it's really, really, really wide. Now, if you look at the issue of restraining that person who is arrested, a person may not be restrained, as we can see from the ACJA, except that suspect is unwilling to comply with the arrest being made. Somebody who is trying to forcefully remove himself from the arrest process can be restrained either via handcuffs or maybe a rope or another form of restraint given to that person. Now, it is important to note, one person can never be arrested in place of another. Supreme Court decisions are rife with that, and Section 7 of the ACJA also makes that the position. Something very funny that also happens, of which I have tried to caution my colleagues in that regard, especially the junior ones, is that you find out that the police can come and say they need an arrest warrant against unknown persons, that they just want to go into a place where they have a lot of hoodlums. Since they don't know them, they just need an arrest warrant, and we do not issue such arrest warrants. Because you can easily go there, and then instead of unknown, they now fill out that person's name and use it in arresting him. And then maybe it might be for a political gain, or some people that are actually having issues between themselves, and that will now lead to something else, or maybe an allegation that the magistrate is colluding with that lawyer or some other party to effect a gain. We don't allow that whenever the prosecutors come for it. So also, the ACJA has taken its time to make sure that arrests terminates. If an arrest warrant, for instance, is given by the court, it terminates, that warrant terminates at the point of the arrest being effected. Anything after the arrest, they must come to court to seek for a detention warrant or remand warrant, which may be granted based on the facts or as devolved in the affidavit in support, and also a summary of findings as per investigations and all that, or refused by the magistrate. And this is meant to take 14 days in the first term, and then another 14 days if allowed. Now, one thing that you, counsel, may have to note is that once a detention order or warrant, a detention order is given to the prosecution, you must follow it up to make sure that on the return date, the said prosecutory agency comes back to the court to say what they have done with the suspect. If they're going to keep the suspect an hour after, they must explain to court why and possibly seek for another remand order or an extension to another 14 days. But certainly not them keeping such a suspect there at their own whim and caprice. So what I do in my own court is simple. Once I put a return date, on that return date, it will be called, the file will be called in the open court. And I'll take note of the fact that possibly the prosecutor had some issues and couldn't make it to court. He shall be served a notice as against the next adjourned date, which won't take more than 48 hours. Now, on that date, if he's not in court, I shall formally strike out that order I gave and ask them to be served with the notice of the fact that the detention warrant or order which they have with them is no longer effectual. And in such a situation, they can't say it is my detention warrant they're still working with that made them keep someone there for that long. So we must be active in order to protect the rights of persons or detainees. Then when you come to bail, bail, interestingly, is availed to everyone who is seeking it. The administrative bail from the police is always there. They consider their own factors. And then when they come to court, they will still need to look at what the court has been able to afford. In my years of practice, bail can be very, very tricky, especially where there are political interests involved. I've handled a matter related to a high-profile politician who, before you know it, it was the time of Potom Idris. The IG then, he sent someone to me, to the open court, that they should tell me that I must refuse those persons' bail. So I wouldn't argue at that point. I simply said, okay, and I proceeded to go into the open court. When I got into the open court, I heard both parties. What was the offense of the persons involved? That they were picketing around a building and preventing police from arresting someone. So how does that constitute an offense that bail should be denied of? And when I spoke with them, they all had jobs, good jobs, and they all seemed like responsible members of the society. So why would I deny them bail? I now took my turn to go through the position of the prosecution married to that of the defense and find out that the bail must be granted. That day, all levels of intimidation were used against the court. DSS officers, masked, came into my court. I was in zone 2 then, and I'm still in, and I've been posted to zone 2 now again, coincidentally. They came into court masked with their guns, trying to intimidate me, and said they needed to move the suspects out. After I granted them bail, and they were trying to perfect their bail. So I had to insist that the official closing time of court will be around 4 p.m. If that time does not pass, they have no rights, in as much as they're still trying to perfect their bail to take them out, they should get out. And I sent them out and asked my outlet to secure the door, which I did. So we must always be alive and responsive to our duties and obligations, both as judex and active players in the temple of justice, to make sure that the rights of persons are not trampled upon. Now, when we come to the issue of bail pending appeal, you know, bail within the matter, the matter is constitutional. One thing we don't realize is bail pending appeal is not particularly guaranteed by any constitutional provision. It lies within the discretion of the judex, who, after analyzing his own position that led to the judgment, in which he decided that this person should go to jail or should serve some time for a particular offense he has committed, said bail can at that point not be looked at as, after all, he's entitled to it as of right. No, it is at the whim and caprice of the judex. And that is how it stands. But of course, bail pending the determination of the matter is a constitutional right that must be looked into, that must be taken seriously. And of course, we all know the basics. Someone who commits murder will find it very, very hard to be afforded bail. Maybe a very well supervised bail may be granted him, maybe in a hospital facility, or maybe in a restricted home outside the prison walls. But of course, he must be prevented from interacting with the society so as not to commit similar crimes or evade justice. That's the way we hold it here. So I will field questions quickly if you have. That is the only way we can get this through, because my time is way off and I need to be running. I'm sorry for not covering as much as I would have loved to, but kindly pardon me. You can ask me questions, maybe a few or two, then we'll be gone. Thank you. Thank you so much.
Thank you. I really appreciate your practical experience that you shared with us. Two things that resonate well with me is that we should try so much to follow up on the man orders as granted by the court to the letter, such that on the day the court has indicated the return, counsel should ensure they also return to court and demand for answers to what has been done. And we also appreciate the practical experience you shared about interference from above and how you ensure that you did what the law requires. If we had things like this going on in an bench in plenty numbers, it would have made so much sense for us, such that nobody is detained at the whim of anyone at the top. Appreciate that so much. Take cognizance of the fact that the time for prayers is getting close. So as indicated, I take a few questions so that you can also speak practically to the experience of lawyers in the house. Distinguished seniors, if you have questions related to what has been discussed the last 2 days, especially as it relates to its worship, it is time to indicate. Let us take them before the prayer time.
I would appreciate a question or two, please. It might not necessarily be from what I've said. It might be from any issue related to court as per bail, arrests, and all that. Yes, please. Thank you.
Thank you so much. Thank you so much, Your Worship, for that very insightful and very practical intervention. I think she is out, but please, if you have any questions, please raise your hand and raise your hand, or you can type it out if network, you're not in a place where you can talk, you can type it in the chat so that we can take advantage of his worship's presence with us here. Maybe I'll ask if I could use the opportunity to chip in to ask a question. And my question I'll center my question around remand orders, particularly with regard to return dates. Your Worship, But there some of the challenges, not with FCT now, but I'm speaking generally, from my interactions across Nigeria in different states with the ACJ, I hear that some of the challenges that arise often have to do with the use of with the who is responsible for ensuring the return of the person who is detained, the detainee. I see that in some cases, in some states, the ACJLs make it the responsibility of the court to include a return date, and also the responsibility of the fact in I think in Niger State, the court has a registry. There's a central register of detainees and remand orders, and the registrar of each court is the person responsible for monitoring that register and ensuring compliance. That is the return of the detainee. So my question would be, how does it work in the FCT? Because I'm not sure that I don't think the ACJA has a specific provision for that. And then maybe the second leg of the question would be, how can lawyers, or what would you advise would be the best way for lawyers to perhaps challenge a remand order if maybe there was made, if the affidavit that was used maybe contains facts that are not true, or for whatever reason? So those are the two legs of my question with regards to remand orders. Thank you, Your Worship.
Okay. Thank you so much, Folarinwa Aluko. Like you've rightly noted, in the FCT, we do not have a strict procedure as regards how to effect the compliance with the return dates from the detaining authorities. You know, we do not have any stricto sensu provision. So what we do might be out of each magistrate's judicial discretion, not what is actually put in the books. And I have always mandated my staff to make sure on that return date, the file must be called, must be listed. First of all, it must be listed on the course list of the day it's meant to be returned as one of the matters to be heard. That's step number one. Number two, once it is heard, I, as Judex, will mandate my registrar to convey to the detaining authority that they have skipped the return date and they have 48 hours to appear before me, so that I can vacate the order that I gave. And this order is as per remand. Now, if within 48 hours they are not in court, I will vacate it, because my registrar should bring it to my knowledge. It will be in the open court. I will vacate it. Then I will now ask the registrar, even if there is no counsel or representative of the, what do you call them, of the defense present, I will mandate the registrar to go to the detaining authority and serve them my order, or telling them that I have washed my hands of the detention warrant, and they are now holding that suspect, if he's still with them, illegally. Now, this is where persons who are representing the defendants or detainees will come in to come and do the needful of maybe filing a fundamental rights action or something against them. But of course, the court cannot leave at that point and continue pursuing. Have you released them? Won't you release them? When are you releasing them? And all that. I have done my part, and I have washed my hands off the order that led to the detention of such persons. And that is that part. And that's how far I believe I can, within the constraints of the law and constraints of the economy, go as Judex. That is that. Then number two, when you talk of the fact that how do you challenge false depositions in an affidavit used in obtaining a detention warrant? That's your second leg. It is very, very simple. The first step to take is to come as the counsel of a detainee, come before court and ask court for the records that led to the detention. Once you have these records, which will be availed you, you look at it, you go to the depositions on oath as made by the detaining officer. If you find out that there are facts there which are not true, or facts there which do not in any way comply with the position that you know as being the truth, you can at that point go and set up your own counter affidavit and seek the court to hear you immediately. You get your what do you call it, affidavit of urgency, wherein you will state that this person is being detained unlawfully and on a conjecture of lies that can hold. And then seek to expose the truth to the judge. The judge is not an investigator. We are secluded. We are restricted to our seats in the courtroom. We won't go out and look at what's going on out there. So when you bring these facts and you open it up, that's how we will be able to say, okay, in view or in the light of this, especially after hearing from the other side, because we also serve them and give a date for both parties to now come and argue it out, then we will now say the detention was wrong and we'll vacate it. It does not mean if we've already given an order, we can always vacate it if such was founded on falsehood. It can only be sustained if it is true as to the facts. And a lot of times I have had to vacate some of these things, in my court.
Wow, thank you so much. Thank you so much, Your Worship. Your Worship is such a repository of knowledge, of wisdom, and of law. Thank you so much. I was telling participants yesterday that for many people, many lawyers who don't know you, that most lawyers know that once they come in, if you're coming to, they're coming to Your Worship's court by 9 o'clock must be court, because by 9:30 the court has already run through about half of the course list. Your Worship, we thank you for your industry. Thank you so much for that intervention. I don't know if there are any other questions. Any questions for His Worship? Okay. Mr. Mobon, do you have a question or your? Okay, Mr. Mobon is one of our elders branch. Okay. No other question, none. Okay. I think I don't have a question, but
Hello?
well, I guess, yes, Your Worship.
Yes, please.
Yes, sir. I would like to find out, so one of the challenges now let me speak now as a defense lawyer. One of the challenges that lawyers face when dealing with, especially back to remand orders now, is that with agencies that obtain remand orders, is that most times the orders are not served on the defendants or their counsel, cases where they actually have counsel. And in particular, there are some agencies that even hide the fact that the remand order has been obtained. And sometimes they use the opportunity of varying conditions or providing very stringent conditions for administrative bail as a cloak to kind of mask the fact that they have actually obtained an order. What are some of the ways that you think, not for lawyers now, but what are some of the creative ways, I guess, that that courts can, or do you think, would it be appropriate? I'm trying to think along the lines of maybe law reform now. Would it be appropriate to insert or to propose a reform for the ACJA that that would require agencies to serve the detainee now with a copy of the remand order, so that at least the person is put on notice as to one, which courts, or as to one, the fact that there's a remand order for their detention for a particular period, and then two, that the courts where that order emanated from. I think this played out recently in the Malami case, where he was arrested and a remand order had been obtained. Then his lawyers filed a fundamental rights enforcement lawsuit and a habeas corpus application, and another court granted him bail only for them to find out that a remand, I think by the time the lead prosecutor issued a statement to the effect that a remand order had already been obtained. So what do you think in terms of the future of the law, in terms of law reform? What does your worship think about? Would it be needful to insert a provision that speaks to maybe ensuring that the detainee is served with the remand order?
Okay. Thank you so much for this question. It is a question that ordinarily, if we are to employ judicial pragmatism and to be also proactive, the question will naturally answer itself in line with what we have within our laws already. If you recollect, the ACJA makes it mandatory that a suspect who is going to be arraigned before court must be made known of his offense or offenses before being arraigned in court. He is not meant to be taken to court and it's in court, he will now be read out the charges against him. He should be made known of this at least a week or so before he is arraigned in court. If that is the position with ACJA, why can't a remand order not be made available to the suspect? He must be aware. And since it is not already captured in the Administration of Criminal Justice Act, we need to bring it up for same to be included in view of making the law better. Yesterday, I was attending a symposium where my Lord, the Honorable Chief Judge of the FCT High Court, signed up on the new practice direction of the FCT High Court rules, sentencing and all that, guidelines within the Attorney General's office. Now, Professor Akinseye George was there, Professor Deji Adekunle was there, the Attorney General of the Federation was also there, and all of them agreed that, of course, the ACJA is still a working project for now, is not perfect, is not complete. We need to keep on tinkering with it till we have a perfect document. And that is why I like engagements like this. When we rub minds, both from the bar and the bench, we'll be able to say, this is what is lacking, and this is how we can make it work. So if you don't mind, I would appreciate if you can try and contact, especially Professor Akinshaye George. I have his number somewhere. I can make it available if you can't reach him. But try and reach him and see how he can, introduce you to the committee. There's an ACJMC committee. And then from there, we can see how some of your observations can be included in the document, so that when it is now time to holistically work on it, we will now have that also being part of the amended version. Thank you.
Thank you so much, Your Worship, for that very robust and practical. I think Sheyi is back.
Okay.
Yes, Your Worship. I don't know if Your Worship has any other words, if there's anything else you'd want to share with us.
Okay. Okay. I want to plead with my colleagues, lawyers. I want to plead with you guys that we should always stand with the truth and should never allow anybody, no matter how high or no matter how compromised, to make us leave the path we have sworn to protect. I don't know how many of us are here. How many participants do we have here, please? For Lauren.
Yes, Your Worship. At the moment, we are 25.
25 participants.
30, 25, 30.
Okay, great. Now, why I'm saying this is that I have been in the. Can you hear me?
Yes, Your Worship. About 100 people registered to participate.
Okay.
Yes, you did. Yes, you had about 60, 30.
Okay.
Yes, sir.
Okay. Now, why do I say this? Is this? Some time ago, what? Okay, that's fine. Some time ago, a lawyer. I've been in this job for 22 years. Okay, and in the course of my practice, I've always had fairly okay response from lawyers generally. And then I've always tried to explain to lawyers that you can get your way, but not necessarily via sharp practices. You can get your way, you can get what you want, but not via sharp practices. Now, what are sharp practices? Sharp practices are those things that will get you results, but via a very bad and odious, out of the law kind of arrangement. Now, I encountered a lawyer who, in my 22 years experience as a magistrate, a chief magistrate, I have never encountered. And I encountered him last year. This lawyer is meant to be before the Legal Practitioners Disciplinary Committee now, but by virtue of the fact that the committees set up for reviewing that particular matter found me to be guilty of the accusations the lawyer made without substantiation, the lawyer is now smiling that he has dealt with a magistrate. Now, I don't want to go into the facts per se, but I'll give you snippets. A lawyer appears in court for his matter as a defendant. He files for a preliminary objection to have the matter struck out into jurisdiction. I reason otherwise. It's not what the law says. This matter can go on. I have jurisdiction and I so rule. What is the next thing for the lawyer to do? If you're not satisfied, it is to appeal that preliminary objection. But no, the lawyer goes to sleep, wakes up one day and says that the matter was conducted behind his back. He had no notification whatsoever. And as such, he believes I am complicit. Now, in my 22 years again, I must come to the facts again. Never has a lawyer written any petition against me for complicity. Why is that? In the open court, even if you lose, you will know you lost. And if you won, you will definitely know that you've won this matter. Because it's so clear, it's so plain, there's nothing hidden. And if I find out that there are persons who are involved, who will definitely bring about conflict of interest, like family members, friends, relatives, or relatives or friends or something, I will recuse myself and then move on. It's that simple. Law is not hard. It's all there for you to see. But this person, knowing that what he's saying are a tissue of lies, went on with it, had me suspended for 6 months, and I'm just resuming. And I'm not just resuming. He is gloating with the fact that he has succeeded in making sure that I get the axe and I get demoted. All out of what? A conjecture of lies. And this is a lawyer who is not a young man, who ordinarily should have taken his silk long ago. Practices in Ibadan, came over to Abuja to host some couple of matters, and now decides to do this. It is really very, very sad. And it almost made me to dump this profession. Because if lawyers can, for whatsoever reason, go to that extent of fabricating lies in order to achieve whatsoever aim, whoever is piloting their course, then it's a very bad day. It's a bad day for the judiciary. It's a bad day for the bar. And what made me not leave is, if I leave, who will be taking over? Who do I leave this position to? My years of experience, my years that I've put in, and the way the job comes to me naturally. I don't have to force it. I don't have to stress it to know it. Who will be that person that will come in to do this? So that's what halted my pen as I was trying to pull out. But we thank God for his mercies. We thank God for everything. I am here today and I'm back and I'm sitting, though in a whatever capacity, but I'm sitting and I'm here and I'm available for posterity and for the future. But please, lawyers, do not, no matter what it is, do not engage in sharp practices and do not engage in the pull him down syndrome. Because I can assure you that lawyer who orchestrated all of this had nothing, absolutely nothing. When he was asked to substantiate his claims, he said he firmly believes. And you and I know that belief, no matter how strong, can never ground a conviction. A year one law student should know this. Not to talk of someone who ought to have taken silk over 10 years ago, if not more. So I pray that we get to see and interact more on forums like this. And I also pray that you all get the best of what you seek, and God bless you all. Thank you.
Wow. Thank you so much, Your Worship, for that piece of advice. And I'm very sure that members, those of us here, all of us here, including myself, will take it to heart. I actually did not know about this incident. And I can also vouch, I have appeared before Your Worship one or two times several years ago. And I can vouch for the industry of Your Worship. In fact, sometimes I never informed Your Worship, but sometimes I'll come to court, and if I was in another court, my matter was done. I would come to, when you were in court 8, I'll come to court 8 and sit down to observe proceedings to learn. Because one thing I've noted is that Your Worship always would take time to explain, even in cases, I remember things like dressing. And I think that at a point there was a notice to lawyers about the dress code. If you're wearing a wing collar, you come to court, you must wear your bib. And no shades of, no blue, no brown, no gray. If you're wearing black, you must wear a black suit, a white shirt, black tie. And I also remember on one occasion that Your Worship drew the court's attention. There was a matter that was called, and Your Worship told the court, or told the other party that, oh, you knew one of the parties. And it was so shocking to many lawyers who were in court. And Your Worship asked the other lawyer, he said, you asked the court, or you asked the lawyer, are you comfortable with my proceeding to hear the matter? And the other lawyer said yes, that he knows Your Worship, and that Your Worship is a man of justice, and that he believes that justice will be done without fear or favor to anyone. So it is rather unfortunate to hear that this incident occurred. Perhaps, but I know that in time, Your Worship will be vindicated. But thank you for not leaving the profession. And thank you so much for also sharing some of your wisdom, just a little tidbit of your wisdom with us. Thank you very much, Your Worship. It's been a pleasure as always.
Thank you. God bless you.
God bless you, sir.
So, if I may go now, I appreciate
Yes.
Okay.
Yes, Your Worship. Yes, Your Worship. Yes, Your Worship. Thank you, sir.
Okay. You're welcome. Bye.
Bye-bye, sir. So I think Mr. Shei is back, but I think this would be a good place, because I know it's time for prayers. And as His Worship is leaving, I guess we have actually covered, His Worship has covered most of the areas that the other areas that Uche would have covered. I think this is a good place for us to close. The other thing I wanted to share with us, I think I can just share it as a material. I wanted to share the arrest protocols, what should happen when a person is placed under arrest, the things they should be informed of, sequence, and then what happens. So you have the person should be notified of their Miranda rights. Then a search is conducted for the purpose of taking an inventory of what is on the person. That inventory search is not an inventory search is not a legal search. An inventory search is just taken for the purpose of documenting the things that the suspect has on them. It is not the same as a search. So it does not give the enforcement authority the right to open their phone and to start searching it's not a search for that purpose, it's a search for inventory. And the ACJA lists out how the inventory is to be recorded. So an inventory search is conducted, then the suspect is documented. So the information is taken down, their name, their full name, their details, their NIN, BVN, and so on. All that information is captured before, and all that is to be done within 24 hours of arrest, not later than 24 hours of arrest. So I'll share that material. It's all in the ACJA and various ACJL. We'll just share it with us so that those of us who want to go for prayers can go for prayers. The link for CLE attendance is in the group chat. The link is in the group chat. I don't know if anyone has any questions from my session. The link is in the, excuse me. So I'll hand over to Shay, who is doing a fantastic job of helping us moderate the meeting. So let me hand over to Shay.
Thank you so much, Mr. Chair, for taking over when All right, we've had a very good session. It's a good time to appreciate his worship for sharing his insights and practical experiences he has had on the bench. We also very much empathize with him for the recent experience he had. Like I just said, we hope for his vindication in no distant time. All right, in case we still have, in case we still have any further questions, they can be sent in either in the chat box, or we can find a way to get across so that we can take them as other fora we discuss. It's a continuous conversation. Arrest and bail issues happen every minute, every other day. You may not have a client today at police station, but on Monday morning, you will get an invitation to come and represent somebody at the police. So we all have that experience in and out from day to day. All right. So I want to again thank everyone, and to our Muslim brethren who are going to be praying now. We pray that your prayers answered by the Almighty. We want to thank everyone who has been here today with rapt attention. We greet our people from the CLE unit. Madam Halima Yusuf, I can see you there. Thanks to all our seniors, all our colleagues who are here today. This series continues. In no distant time, we'll release the flyers again for the next topic. We've dealt with this very well. We'll roll out the next flyers for the next topic, and we trust to expect to see you attend. We'll be bringing in other dynamics in this legal practice. Thank you so much. Please encourage lawyers, especially young lawyers, to attend these sessions so that they can get well equipped for the practice ahead of them. Please do have the best of the weekend. Again, my name is Sheyi Arushebe. Thank you so much. Once again, the CLE point link is in the chat box. Please, it is self-explanatory. Just fill in your details and submit. We'll keep the meeting live for a few minutes to accommodate everyone to fill in their details. Thank you.